Hello, everyone. My name is Gina Jackson, and I am the Program Director for the National American Indian Court Judges Association. I am Western Shoshone from Reno, Nevada, and it is my pleasure today to introduce Healing to Wellness Court's Key Components and Standards webinar, and this is just the second webinar in a whole series that we will have throughout the year. We will be sending out announcements about the upcoming webinars that are all free of charge and open to everyone. So thank you for joining us, and we're excited to go ahead and get started. I would like to introduce our presenters today. We have Lauren Van Schulfgaard, who is with the Tribal Law and Policy Institute. She is the Tribal Law Specialist, which she does technical assistance to tribal courts, including Healing to Wellness Courts. She researches legal and policy issues and works to support tribes with governance and sovereignty. Prior to coming to the Tribal Law and Policy Institute, Lauren served as a law clerk for the Native American Rights Fund and the Legal Aid Foundation of Los Angeles. Lauren is licensed in the state of California and currently serves on the board of the National Native American Bar Association, the American Bar Association Center for Racial and Ethnic Justice, and the Tribal Courts Council of the American Bar Association. She recently finished serving a 3-year term on the board of the California Indian Law Association, graduating from UCLA School of Law, focused on tribal and federal Indian law. She also, while in school, served as the president of the Native American Law Students Association and participated in tribal law clinics, including the Tribal Legal Development Clinic and Tribal Appellate Court Clinic. She has been with TLPI for 5 years and is just an amazing asset, and we're enjoying working with her. We also have Judge Carrie Garrow, the Chief Judge of St. Regis Mohawk Tribal Court. Carrie has been doing work in supporting Healing to Wellness Courts for 17 years. She formerly served as a visiting assistant professor at Syracuse University College of Law and Syracuse University's Native Studies. She received her undergraduate degree from Dartmouth College and law degree from Stanford Law School. She also has a master's in public policy from the Kennedy School of Government at Harvard University. She's a consultant with Tribal Law and Policy Institute and has co-authored Tribal Criminal Law Procedure with Sarah Deer, in addition to writing several articles on tribal law and governance. She has served as a tribal consultant for several nonprofit organizations, including the Harvard Project on American Indian and Economic Development and the Native Nations Institute. In 2004, Judge Garrow joined the Center for Indigenous Law. The center conducts legal and policy research relating to all aspects of indigenous sovereignty, provides technical assistance to indigenous nations and governments, offers education and training on Indian law and policy issues, and promotes a great understanding of law, government, and the history of Native people. So please join me in welcoming our presenters as we get started in the webinar for Healing to Wellness Courts, Key Components and Standards.
Thank you so much, Gina. Hello, everyone. This is Lauren. We're really pleased to be working with the National American Indian Court Judges Association as well as the National Council of Family and Juvenile Court Judges. It's a real pleasure to be here. So this webinar, Healing to Wellness Courts, Key Components and Standards, is intended to provide an overview of the wellness court model. We'll be going over both what the key components and what the standards are, what are we referencing when we say those terms. But first, to start us off, we would like to get a sense of how you all are and what your relation is to wellness courts. So we're going to start off with a poll. Here's a slide, and we have an interactive poll here. We just want to know, do you currently have a Healing to Wellness court? Is it either operational or are you planning? So you'll see several choices there. You can select more than one if more than one applies to you. So we're inquiring about adult criminal, juvenile wellness courts, as well as dependency wellness courts. So we'll give you a chance to select your answer or answers real quick. And you want to say hi, Carrie?
Sure. Thank you, Lauren. Hello, everyone. I'm excited to be here. And as Lauren said, we're going to talk about the Healing to Wellness Court key components and the standards. And I'm excited to see you all jumping on and sharing with us exactly what your roles are, whether you don't have a Healing to Wellness court, and perhaps that's why you're here, you're thinking about doing it. And that always just helps us focus on so we know who our audience is, which can be challenging when doing a webinar because we can't see you.
So I'll give you a couple more minutes, or seconds rather. Just by way of background about the Tribal Law and Policy Institute, as Gina mentioned, we're a training and technical assistance provider. We currently have a grant through the Bureau of Justice Assistance to provide training and technical assistance specifically for Healing to Wellness courts. This includes the adult criminal model, the family dependency model, and the juvenile model. And what's really neat about this is not only can we provide training like these webinars, we host our own enhancement training in September, we go out, but we also provide individualized technical assistance to tribes that would like that. At the end of this webinar, I'll have my contact information, but you are always free to contact us either for big technical assistance, you want us to come out for 2 days, or for just a question that's arisen in your court and you'd like a third party to chime in. We're available here for you at no cost to your tribe. So with that, let's turn to our poll results. It looks like we are a little bit across the board, but a lot of no's, 7 no's that you don't have a wellness court nor are planning one, which is great. This webinar is for you. And then otherwise, it looks like we're pretty even across the board. Here, I'll end the poll so you can view votes. There we go. Yeah, so that's fantastic.
Yes, I think this is great. It's, I can tell definitely some of you are planning the various different kinds, and so you're in the perfect place. And for those of you who already have operational courts, we always tell people in our trainings, it's always important to come back and revisit your key components and what you're doing, and especially the standards as well.
So moving right along, the key components. Back in the day when drug courts were just starting out, they started out in stateside, and as a way of sort of providing some kind of foundation to this movement that was taking the country, they developed these key components, sort of the foundational pillars for what should be involved when creating a drug court. Tribes, looking at this non-adversarial model intended for treating substance use disorders, were very interested, but found the state key components to be a pretty poor fit. They were very rigid and very much had a state governing structure in mind. So the key components were sort of reimagined for tribes. A lot of the same pillars, such as entry, eligibility, targeting high risk, high need, providing holistic treatment, those are all still there, but the tribal key components include a couple of additional things. They focus more on community involvement, involving the family, not just serving the individual, including culture and tradition as key aspects of providing holistic treatment, and keeping tribal sovereignty as a primary consideration. Oftentimes, I am a big stickler for referring to wellness courts as a court rather than a program. This is a court part of the tribal judiciary, and so it's important to keep in mind the overall Native nation building that is encompassed with that. So the key components, they are a publication originally published in 2003 and then updated in 2014. So this is just a snapshot of that cover. And you can find the key components at wellnesscourts.org. It's a publication available for free online. The standards. Back in 2013 and then again in 2014, the National Association of Drug Court Professionals came out with standards for the very first time. Prior to that, we had the key components. The key components were sort of generally agreed upon pillars that we should all be focusing on when developing our drug court, but they weren't research-based. We sort of all anecdotally agreed, but there wasn't any real data backing that up. Well, after drug courts have been in operation for 20-plus years, we do have some data, and the NADCP took a look at that data and developed these two sets of standards. Because it's data-driven, it doesn't address every single component of a drug court. There are lots of areas that are sort of left to the key components simply because there hasn't been research in that area yet. So they're not all-encompassing, but they do touch a lot. I would say for 90% of the time, these standards really reinforced what we were already practicing under the key components, but they provide, I think, really helpful guidance in a lot of areas. One thing to keep in mind, however, about the standards is that little to no research has been conducted on tribal drug courts or tribal healing to wellness courts. It just hasn't happened yet, and so that means that these standards are really state-focused. I think there are a lot of really useful lessons learned that we can take from the standards, but like most research when it involves justice systems, we have to take it with a grain of salt for how it will apply in Indian country. So this sort of covers some points I was just discussing. They're research-based. They operationalize the key components. Another big goal for the standards was that the NADCP, but also drug courts just generally, wanted to have some more tools to help them apply the key components, to help sort of satisfy, are we doing this right? You know, we think we're doing a good job, but how exactly can we measure that? And so this allows to provide a little bit more efficient fidelity to the model. It also highlights some important judicial questions such as due process. How exactly can we ensure that we're applying due process when embarking on this really innovative non-adversarial model? And at the bare minimum, how can we ensure that we're not doing worse than if we had no drug court whatsoever? How are we ensuring that we're at least not harming the participants that we are seeking to serve? Another important consideration for these standards, which is why we're including it here when we're talking about the wellness court model, is that if you and your tribe are ever going to apply for federal funding for your Healing to Wellness Court, you will likely be asked, how are you going to comply with the standards, which means you're going to need some familiarity with the standards. So we want to make sure to provide that here so that you are ready to go for your next CTAS or BJA grant application. So here are the Healing to Wellness courts. We have, for a couple of years now, looked at the key components as a circle or as a circular concept. This is because there's really not a great linear or logical way to approach the key components. Yes, they're numbered 1 through 10, but really you could start anywhere on the circle and approach a Healing to Wellness court. It makes this webinar a little bit of a challenge and a special challenge for anyone who's new to the wellness court model, but nevertheless, we're going to get through it together. For those really paying attention, you might notice that 2 and 3 are out of order. Would you like to comment on that, Carrie?
Sure. So, so Lauren was reading my mind and didn't even, well, I didn't realize it. And because that jumped out at me today. And for numerous years, we sort of argued over whether entry should come before eligibility, and they really go together. And I think you'll see as we talk about that today, How can you determine how, the entry key component talks about how someone gets into Healing to Wellness Court, but most times you really want to know whether they're eligible. So, Lauren highlighted that by switching them, that there's really no right way to go around the circle. I just always remind people, one of the reasons we put it in a circle is to remind us to keep going around the circle. Like when you feel like you've mastered one key component, keep going and start working on the others. But just because you get to 10, go back to number 1 and assess where you are. And we'll talk a little bit more about that as we go on.
So for the remainder of the presentation, we're going to be walking through the key components and then supplementing those with the standards. As I mentioned, the standards are not all-encompassing, and so what I've done is pull different parts of the standards as I see how they're impacted with the key components. This is my personal interpretation of how the key components and the standards relate. I encourage you on your free time to take a look at the standards separately as well as the key components. You might have several different interpretations, but this is just my way of helpfully trying to integrate the two. So we're going to go through the key components in order, and then by way of that, we'll be addressing different parts of the standards. And so with that, I will turn it over to Carrie to start us off.
All right, so we're going to start with key component 1, and I just want to remind everyone, if you have questions, don't be shy, because we can't see your faces. Just jump in the box. It's just like doing Facebook Live. Just type us a question. I don't think you can give us a thumbs up or thumbs down. But please don't be shy if we're using lingo or slang that you do not understand. So, because we're happy to answer your questions. So key component 1, and that is a really good starting off point if you're thinking about planning a Healing to Wellness Court, but even if you've been up and operational for years, it's also good to revisit this, because key component 1 is all about bringing people together. So it's pulling together a team of people that are individually and community-based that have a healing focus. And it's about bringing together a team that brings together not just the judge, who's typically the person who hears either the dependency case or the criminal case or the juvenile case, but it's bringing together a team that can help the judge help the participant. And also not just help the participant, but you're also nation building, because as we know, each one of those individuals out there who's struggling with substance abuse, they play an important role in our community. So as you're helping them heal, you're helping your nation. And I've also found that as teams come together and figure out a way to work together, it also strengthens your government. And you will be surprised at other opportunities that pop up where people will say, hey, we really like this collaborative approach. Can we try it on such and such problem? And it really will increase the well-being of your nation and your community building. So one of the standards focuses on this, and it's standard number 8. And as Lauren noted, so that the standards are listed out not according to key component, which was a challenge for those of us who are kind of number-oriented or when they first came out. And Lauren's done a great job in fitting in the different standards, because you'll note some of the standards fit into a lot of the different key components, which goes to show that the key components are all related to each other. So the research showed how important having a multidisciplinary team in your Healing to Wellness Court. And the research showed that the critically important people are the judge, a coordinator that really keeps everybody together. Of course, then you have your attorneys, your prosecutor, your defense counsel. Critically important is having treatment, some type of community supervision, and then law enforcement. And I've been fortunate to be out in Indian country with Lauren visiting a lot of teams, and not every team has these, and it's really up to your planning team, your nation, to figure out what fits you. Those of us who deal with having concurrent jurisdiction, we may be collaborating with county courts, and maybe we're not exercising criminal jurisdiction, so we might not have a tribal prosecutor. We may be working with a county prosecutor. We may not have probation. But and I do have to mention, though, that the importance of law enforcement being on your team, and sometimes, and this happens in state courts as well, law enforcement is super busy. They have many other things to do. Healing and wellness is not always, something that they focus on a lot, and sometimes that can take some relationship building, but it's critically important to reach out to them and include them in a way that they feel comfortable, and start by building that relationship, and then you can build on that from there. But they play a critical role. They're your eyes and your ears. They know what the participants are doing in the community, usually before the rest of your team members know, and so that's critically important. And the research has shown that as well. So with that, we'll move on to key component 2. So Lauren, I'll hand it back to you.
Yes, so now we're getting into a little bit of the nitty-gritty. Key component 2 refers to entry. How are our participants getting into our Healing to Wellness court? So I have a couple little bubbles here about eligibility and pre or post plea. These are specifically in reference to the BJA Adult Drug Court grant solicitation. They have these little requirements that don't align with either the key components or the standards that you are supposed to be responsible for answering. So I put them in here just in case that's an application that you're going to be filling out in the future. Here's where I think they fit in. But to go into standard 1, one of the big things that the research pointed out was that a lot of Healing to Wellness courts and drug courts specifically, were having they had a subjective entry process. Prosecutors and defense counselors would identify participants that they personally thought would be a good fit for drug court. And while this feels right, like we have a sense of who might benefit from this program, it meant that a lot of potential candidates were being inadvertently denied the opportunity to participate in drug court, whether for explicit bias reasons or for implicit bias reasons. There's also a lot of confusion about what the drug court or the Healing to Wellness court model is. It's just not really clear what the expectations are. Is this better or worse than just going to jail? And so for all of those reasons, it's really critical that as much as possible, we want to strive for an objective eligibility criteria. If you meet X, Y, and Z, you should get into Healing to Wellness court. This helps not just those candidates know where they fit in the overall system, which can be really confusing, but it helps us as a team to be able to ensure that we are properly identifying everyone that might be a good fit and getting them in. So how do we do this? Putting it in writing is a good point, and then communicating that to everyone. It's not just our prosecutors and defense counselors, though those are often the big entry points, but it can be our probation officers, our treatment providers, the judge. I would say this should be communicated to every single team member.
And Lauren, can I just jump in?
Please.
I think this is critically important to those of us in Indian country who are from small communities. I'm from a small community. I have to say, my team, they know pretty much everybody. Someone on the team usually knows, pretty much everybody that comes across as a potential participant. I've seen that in other sites. And sometimes, I think, oh, that person's, they're not ready. And so we automatically exclude them. And so I think it's so important to do the objective, have the objective eligibility and criteria, and don't screen out people because we know their history.
Towards that same point, the NADCP made a really big stance about the access for historically disadvantaged groups, as they call it, often people of color, and their access to drug court. Several different studies showed that African Americans and Hispanics were generally being referred fewer times than similarly situated Caucasian participants. This is sort of a different issue for us in Indian country, primarily because most, if not all, of our participants are going to be American Indian. Nevertheless, I think it's important to at least keep an eye out, particularly for gender, are men and women. For the most part, especially in the criminal model, there are more men. In the family wellness court model, there are generally more women. Is this indicative of the overall population, or is this somehow skewed in wellness court? It'd be interesting just to take a look and see how it's working in your court. So now skipping to another standard, but how it implicates key component number 2. This is, again, towards ensuring our eligibility criteria is as objective as possible. We want to provide advance notice. This trickles throughout the entire wellness court process, but is especially important at the entry point. Wellness court is sort of a difficult thing to describe when somebody's brand new to it. This is going to be a 12 to 18-month program. You're going to have 4 different phases with different requirements in each phase. You're going to be drug tested repeatedly. You're going to need to do community service. There are all these things that you need to do. And so I need to make sure that you know what those are before you agree to participate in wellness court. The other big piece here that I think is important in our entry, but also for the overall wellness court process, is the opportunity to be heard. This is important not just for the due process concerns to ensure that we're being compliant with the Indian Civil Rights Act and any due process protections that our tribe might provide for, but also because the research has shown that people actually do better in drug court if they feel like they have an opportunity to be heard. We're going to be drug testing our participants at least twice a week, and guaranteed at some point one of those drug tests is going to be positive. And when that happens, it's critical that we provide our participant an opportunity to explain themselves. What happened? Research has shown over and over again that when a participant feels like they have an opportunity to give their side of the story, that any sanction that follows that is perceived to be more fair, even if it was the same sanction that was going to come down the pipe anyways. So this is also going to be critical for our entry process. If at all possible, having the assistance of a defense counselor on the team can do wonders for ensuring that this is taking place. Both their presence in the hearing, their presence throughout the entry process, but also having a defense counselor present during our staffing meetings, which we'll be talking about in a little bit. Termination. Besides jail, termination is the other major due process flashing flag that comes up with Healing to Wellness Court. It's critical that as opposed to just like, well, we feel like we've given participant A enough chances, they've used their last one, it's time for termination. That inkling has been used by lots of drug courts, and we have to resist the temptation. And the way that we can do that is by having a really explicit termination criteria laid out ahead of time. That way we're not having to do everything so much by the seat of our pants on a case-by-case basis, but we have a little bit of guidance for what can trigger a termination. This is really important because a lot of our participants have really strong personalities. They might be using substances for a long time and have grown really, really capable at manipulation. And so there are going to be participants that we like and participants that we don't like. And because of that, it can also be really tempting to want to terminate somebody just because they irk you and annoy you and feel like you've given them enough shots. Are we, in fact, treating our participants the same for similarly situations? And double for our consequences of graduation and termination. Are these being effectively communicated before someone signs up for wellness court? I think it's important to note here that especially after someone has had the opportunity to detox a little bit and be in wellness court for a couple weeks or maybe even a month or two, that the requirements of wellness court are going to need to be reiterated, that you may not have fully understood what was coming up, especially now that your mind has had the opportunity to be clear for a little bit. Let it sink in. That's okay, and it's highly encouraged that you go over the requirements repeatedly, in every hearing, have the defense counselor sit down again, but we just want to ensure that everything is above boards. Census and caseloads. You'll note here, drug courts are fewer than 10% of adults in the criminal justice system. So this is in reference just to the adult criminal model, but I think it's fair to say that for the adult, the juvenile, and the family wellness court model, that currently wellness courts are serving a much smaller percentage of the population than those who are in need of drug court. On the flip side, we can only serve what we have the capacity to serve. We can only take on the number of participants for whom we have probation officers to serve community supervision, for whom we have treatment providers to provide treatment. But keep in mind, are we only serving a certain number because that's what we're comfortable with, or is that truly what we have the capacity to serve? I think a lot of wellness courts would be surprised at what they have the capacity to serve, that they just haven't been pushed there yet. So just something for the back of your mind. With key component 3, I will turn it back to Carrie.
Okay, and I wanted to echo what Lauren was talking about with the census and caseloads. I think for healing to wellness, and this also goes to screening eligibility, and it's also a really important when you're doing your grant applications. Generally, healing to wellness courts, because a lot of times we're dealing with misdemeanor cases, have a hard time getting people into healing to wellness court because when you're talking adult criminal, many of our participants have already served time and it's no big deal. I'll just go serve my 90 days rather than spend a year with you, bothering me every week to come in several times for a drug test. And so generally, my experience has been in healing to wellness we struggle with actually getting as many as we want. So keep that in mind when you do your grant applications. Is one, check with your team partners to know, okay, how many additional people can they handle, your treatment people, your mental health people, as you get more people in. But also don't oversell yourself. Well, we're going to have 30 people the first year or the second year, and make sure you take a look at where your people are getting referred from. If they're coming from your own tribal criminal docket, does that actually fit the numbers that you have in your criminal docket? And then keep in mind that sometimes it can be a hard sell coming to healing to wellness court because they're not looking at spending 10 years in prison. They typically tend to be looking at a smaller sentence, so sometimes it's difficult to get them in. So moving on to number 3, screening and eligibility, which goes along with number 2, is that your candidates, one, should be identified early. The reason they should be identified early is because there's this but there's a window where people have been, when you're talking about the criminal context, or if you're talking about a family court, either they've been charged with a crime or their children have been taken away, and that's where they're really thinking about their lives. You also don't want them to wait around for a long time because they may pick up another offense which would make them completely ineligible, or they're going to go, be carted off by the states or the feds for some other offense, or perhaps be in the dependency system, get further along, and it's harder to come back. So you want to figure out a way to identify them early. And you're identifying them by doing a legal and clinical screening, and you need to do both. So the legal one is typically determining whether or not they have any prior convictions that you've determined that you don't want. And then typically you'll do a clinical screening, which does not need to be the full-on assessment, but it's typically just screening to see where exactly they are. You don't want simply users. You don't want to mix users with people who are truly addicted, because you can end up with bad results. So you just need to be very cautious and then promptly figure out the process to get them into Healing to Wellness Court. You don't want them waiting months and months while you're filling out the paperwork. So to look at the standards that are associated with Key Component 3, the first one is the target population. And the research really shows for the state drug courts is to focus on high-risk, high-need participants. And those are typically high-risk and high-need are those who are addicted to either drugs or alcohol, and they're at a substantial risk for reoffending or failing. And they're at any type of less intensive disposition, which essentially means if a person can be successful on regular probation, there's no need to bring them into Healing to Wellness Court, because it's just going to be too intense for them, and they don't need that. You also want to be very cautious about setting people up for failure. And so be careful about that. And like I said, just be really careful about mixing your populations. And in order to determine eligibility, you need to have, you should be using a validated risk assessment tool. And there are clinical assessment tools that are available. They're on the website. And also one thing we wanted to make sure that we mentioned was you can actually look at the standards online. It's a lengthy document, but they're really handy because each standard is broken down into different parts, and then there's a commentary talking about the research. And so you don't have to sit down and read the whole thing all at once. Sometimes if you're just struggling with a question, either you're planning or your team's dealing with a problem, sometimes it can just be useful to pull up the standards and just look at one or two areas that might address the issue that you're having. And so, which brings us to the question of, well, what kind of crime should disqualify a person? So I believe, and Lauren, correct me if I'm wrong, that if you're receiving the grant from BJA, which is the adult drug court funding, not CTAS funding, but adult drug court, violent felony offenses are still, you have to exclude them. I don't think they've changed that, right, Lauren?
They haven't, which is so interesting because the standards actually identify that violent offenders might actually be the exact population that we want to be targeting with drug courts. But the federal funding that funds most of the drug court grants specifically limits no violent offenders. Now, they define violent offenders. It's the federal definition, and so it's any violent offense, usually involving a weapon, that has been sentenced to a year or more in prison. That means that if you are not currently using Tribal Law and Order Act enhanced sentencing, that you might inherently not have any violent offenders, at least under tribal law, because all sentences are a year or less. And this is the triggering offense. That limitation also applies to CTAS Purpose Area 8 for juvenile Healing to Wellness Courts because it's the same funding stream.
And the way that our team does it, because our participants come from our local town court, and they'll only refer us misdemeanors. And so we might have an individual who maybe got charged with a felony, but the county DA is willing to reduce it down to a misdemeanor, which would then make him eligible. So that can also apply when you're talking about violent offenses as well. That, if, as you work either with the tribal prosecutor or someone, if they meet all the other criteria, you could arrange a plea deal so that they're not charged with a violent offense. And I agree with Lauren. It's a bit ironic that we still have this limitation if you're taking federal funding, but the research is showing those might be the individuals you want. And I remember several years ago, we went to the big NADCP conference, and they have a parade of transformation where graduates talk about it, and they had this one individual up there, and I don't remember what he had been charged with, but prior to coming into their drug court, but my guess is I don't think he was specific. It was probably a violent offense, because he talked about he was actually, they were driving him to prison, and he was like hardcore, like manufacturer, meth, biker, and going away for a long time. And for whatever reason, they saw an opportunity in him, and he turned his life around. And so those are the people you're really looking for, and you kind of think there's no way that person's going to turn his life around. But a lot of times with your team, you have the ability to get them back on track and help them with a sober lifestyle. And so you're looking for the participants who pretty much everybody else has given up on. And we're still very cautious about, in our Healing to Wellness Court, about taking individuals that might be a threat to community safety. And so that's something to think about. But okay, so we also sometimes a person might be disqualified because of treatment, but you should be cautious about that, because if you have the treatment available, because many people who have addictions also have co-occurring mental health issues. Not all of our tribal communities have the ability to work with the medical treatment providers that do methadone, but that'll be a question that's asked on grant applications. And under the federal guidelines, you should not be excluding those people, and if you do, you have to explain why. And typically, the only acceptable answer is because you don't have those resources, and that's fine. You might not have a provider in your area who's willing to do MAT, and that's fine. And so as you're also talking about eligibility, you should, one of the standards looked at the complementary treatment and social services. And this really also goes back to your team, that you should have best practices, best standards are to have mental health treatment available and have your participants assessed, and that they should be treated concurrently and not consecutively, because many of our participants are dealing with those issues, and they need to be handled together. And the research has shown that the drug courts that accepted participants with non-drug charges had nearly twice the reductions in recidivism and 30% higher cost savings. And that's how we do it. We don't just focus on drug charges. If the people who refer, it's the town judge. If that person or probation has identified that they have a substance abuse issue, it doesn't really matter what the charges are as long as they're a misdemeanor. And so, and that really widens your pool. So if you're setting up your Healing to Wellness Court, you wouldn't want to set up your eligibility criteria just looking at drug charges. And this research goes back to that you want to do it quickly. So if they entered, in this example, within 50 days of arrest, they had a 63% greater reduction in recidivism. So like I said, it's really critical to work on getting your people into Healing to Wellness Court quickly. It can be a challenge, especially if you're working with other jurisdictions, because it just takes time. Participants need to talk to their defense attorneys when in a criminal context. Often they need to do it as well, and when they're in dependency. And so it can take time, but it's something that you should sit down and talk to your team and sort of map out. Is this happening quickly enough? If it's not, where's the holdup? Whose desk is it landing on? What can we do, to facilitate it moving faster? And I think with that, we're at another poll.
Okay, quiz time, everybody. It's an easy one, true or false. Candidates with certain mental illnesses or other co-occurring disorders are not suitable for wellness court and should be clinically disqualified.
Okay, so Lauren, while they're answering, we do have a question.
Yeah.
It says, would you elaborate on how you're working with other jurisdictions? It sounds unique, and that's from Kimberly Craven.
That sounds like a Carrie Garrow question.
So we're a little unique here in New York. We were the experiment prior to Public Law 280, for those of you from Public Law 280 states. So New York has concurrent jurisdiction, and so our tribe has relied on New York State to provide that for us. like many of the nations in Public Law 280. And so we work with our town court that is off the reservation and county probation, and they refer us people. Typically what happens is a person is placed on county probation, and as a condition of their probation, they have to complete our Healing to Wellness course. And so we work very closely, our coordinator works very closely with the town judges. She goes to their court several times a month, and we are in constant contact with our county, one of the county probation officers, who we're very lucky. He comes out once a week to our justice building and meets with the probation officers here, or probationers here on the reservation. And so that's how we do it. There are a couple other examples of Healing to Wellness courts who are doing similar things. I don't know if you want to expand on that, Lauren.
Yeah, there are actually a lot of really interesting collaborations that are taking place in Indian country, specifically with wellness courts. The truth is that's a whole nother presentation that we definitely give. If anybody's going to be at the NADCP conference in July in D.C., we will be doing a whole presentation on this topic, as well as at our enhancement training, which I mentioned, which is going to be in September in Albuquerque. And hopefully maybe we'll be doing another webinar on it.
I was going to say that. Maybe we'll encourage Gina to bring us back.
Yeah, but you know, the short of it is there are lots of opportunities for referral agreements to work with neighboring municipalities, with neighboring counties. And in fact, next week I'm going to be traveling to go work with a tribe that's going to be working with their federal U.S. Attorney's Office on a referral agreement. So there are lots of opportunities. And if anybody has specific questions about working with their local neighbors, please feel free to reach out. So it looks like everybody did excellent, perfect score for everyone. No, just because someone has a co-occurring disorder does not mean that they are not suitable for wellness court. If your tribe has the capacity to serve individuals with mental illnesses, then that means that they can also be in wellness court. And the truth is, we actually see much better outcomes because if we don't have them in wellness court, then there's usually nothing. And so we're just going to see the same revolving door for these individuals. And so wellness court is often the best place for that population. So diving into treatment, I'm unfortunately not a treatment provider. As Gina mentioned, I'm law trained, but nevertheless, this is a huge component of our wellness court, arguably the biggest enterprise that we're doing, which makes having a treatment provider on the team that buys into the team critical. It also means that for those of us that aren't treatment trained, it's important for us to get treatment trained. This is especially true for the judges. So for all of these, there are lots of webinars and online training tools on these topics that I highly encourage you that if treatment is not your language, there are lots of resources to help you become familiar with a lot of this vocabulary. One thing I'd like to just highlight here that when it comes to tribes and the key components, the incorporation of culture and tradition is equally important here. There have just been lots and lots of healing to wellness courts that have seen immense benefits incorporating culture and tradition into their wellness court. That's, again, an entirely another presentation, but there are lots of different strategies to effectively do this, whether it's integrating culture into your phases, naming certain parts of your program with a traditional name, encouraging participation in traditional activities, connecting certain traditional elders with your wellness court participants. There are lots and lots of really effective strategies. So diving into the standards, one of the big takeaways is the use of standardized assessment tools and evidence-based interventions. Again, small grain of salt, there are very few standardized assessments that have been proven effective for the American Indian Alaska Native population, and there are few evidence-based practices that have been proven effective for the American Indian population. There are some including as far as the curriculums, the Red Road to Wellbriety, I know is really popular for a lot of healing to wellness courts. They have a website. There are a couple of like parenting interventions that are Indian focused, but other tribes have had success with just other general evidence-based practices. I think the big takeaway for us is that using one of these tools and modifying it for our community is far preferable to trying to reinvent the wheel based off of nothing. Even within wellness courts, we have seen immense success when using an evidence-based curriculum as a foundation for our treatment approach. The continuum of care refers to the diversity of our treatment that we're going to be providing. It's not a one-size-fits-all. Rather, we're using these standardized assessments where we're inquiring into the participant and not just their substance use, but their overall lifestyle. What is their family life like? Are they employed? Do they live alone? Do they have lots of roommates? Do they live with family? What are all the pieces making up their road to recovery, and what do they need from us to help them with treatment? Ideally, our treatment includes an entire menu of detoxification, inpatient or residential, sober living. I know one tribe just received a seed task grant to provide transitional sober living as part of their wellness court, which sounds really innovative, and I'm really excited to see how that works for them. Intensive inpatient, outpatient services, and sort of everything in between. So this means even though we're going to have a structured wellness court with certain phases, each participant might have a slightly different treatment plan that's going to depend on what they need or don't need. Treatment dosages. So this isn't just intended as sort of a ballpark guideline for what you want to be sort of aiming for, is that even though each participant's getting their own individualized treatment plan, generally speaking, we want to be aiming towards about 6 to 10 hours of counseling a week in phase 1. So this is because we know we're targeting our high-risk, high-need participants. As Carrie mentioned, this is a high-risk population of reoffending with a high need of treatment. So because we know they're high need, we know that they're going to be needing about 6 to 10 hours of counseling. So this means, 3 days a week they're going to be going to individual and or group counseling. Generally, the phases are structured such that it's very, very intense treatment counseling in phase 1 that is sort of tuned down as they progress through the phases, while other requirements are tuned up, such as vocational and educational requirements. So this means that around 200 hours over 9 to 12 months. Most wellness court programs are around 9 to 12 months. Some are 12 to 18, but 9 months, assuming a participant perfectly goes through the 4 phases, which is not generally the case. What are our modalities? Participants meet with a treatment provider for at least 1 time a week, probably more in the first couple of phases as we see 6 to 10 hours of counseling. And ideally, our groups don't have more than 12 participants. This is wholly dependent on what kind of treatment is available in your community. Some, there's only so many groups. Some we have more. Ideally, as we'll be discussing later, we're able to provide gender-specific groups. Sometimes that's just not possible. But in an ideal world, this is what we're shooting for. Medications, Carrie was talking about medically assisted treatment. If that's available in your community, great. And even better is that if it is available in your community, the overseeing doctor is in some kind of communication with your team. Maybe they're even on the team, which would be out of this world fantastic. But at least there's some kind of communication so that the prescribing doctor is aware that their clients are also participants in your Healing to Wellness court. Evidence-based treatments. There are a whole bunch of different treatments out there. Again, as I mentioned, not very many have been proven effective within our specific communities. Nevertheless, I know that moral recognition therapy is widely used across Indian country. It's a really great program, especially because the training is pretty accessible, and so a lot of your probation officers can get trained in this. I know some judges have been trained in MRT and have seen really, really positive results from that. The SAMHSA has a list that this link will go to. I believe you have access to the key components in the files. And this is a list of different evidence-based programs that are available just generally as a resource to start with. If your treatment providers have preferred evidence-based practices that they like to work with and have already received training in, great. They're the ones that are going to be providing these curriculums, and so we want to use what they're comfortable with. But if not, this is a great place to start. There have been some research showing that some evidence-based practices work better in some communities versus others. But I think one of the big takeaways is as we're learning more about substance use disorders and our target population, we're learning more that most, if not all, of our participants have experienced some form of trauma. Just the nature of substance use, particularly because we often see it in multiple generations, means that something traumatic has happened somewhere down the line, if not multiple times. And so it's really critical that we provide services for that trauma. This doesn't just mean, this isn't just applicable to the treatment provider. I know some courts have had really, really great experiences having someone perform a trauma walkthrough with their wellness court in which a provider comes in and sort of from the participant's perspective, how trauma-informed is this court? Maybe in your wellness court, there is a law enforcement officer who keeps their hand on their weapon at all times. This can be a really anxiety-ridden experience to be sitting in the same room with that. Maybe the tone of people's voices is very loud and authoritarian, putting a lot of people upright and rigid, making a flowing hearing less likely. If you're at all interested in something like that, I can help hook you up with how to get a trauma walkthrough. But it's just to say that this is applicable to the entire wellness court, not just our treatment provider. The other thing in here, this is a quote from one of SAMHSA's resources. It's unfortunately the only thing they had to say about Natives, but I thought it was really interesting that I think there's finally a little bit more widespread acknowledgement that, particularly in Indian country, we're facing trauma not just of the individual, but of multiple families, multiple generations, going back way past just the substance use disorder, that the substance use is often a medication for something much larger going on. And if we're going to even pretend to tackle this substance use disorder, then acknowledgement and addressing some of this intergenerational trauma is going to have to be part of our wellness court approach. So again, going to our treatment menu that is available, the standards really encourage the use of peer support groups. I think this has been present at every single wellness court that I've ever visited. This often is AA or NA groups, but though it doesn't have to be. But any sort of group that is available for peer support. Some wellness courts actually employ peer recovery support providers. These are individuals who are in recovery themselves, but may or may not be staff of the court and are assigned to participants to help facilitate their progress through treatment, which can be really effective if that's something available in your community. But both the peer support groups and the particular focus on continuing care, I think, are really important. I think it's pretty common, and Carrie, I'd be interested on your perspective here. the structure of Wellness Court is really intense. We're asking a lot of participants, and especially in the early phases, they're very resentful of it. But as we progress into the later phases, 2, 3, and 4, the structure of Wellness Court becomes sort of a crutch. It's easier to structure your life when you know you're going to be held accountable to multiple drug tests, and you know you need to show up to all of these things, and someone is continuously watching your back to help support your recovery. And then you graduate, and all of that just goes away. And so we see it's really common to see relapse in phase 4 as people are preparing to graduate as sort of a self-destruct button, knowing that the support of Wellness Court is going to be going away. And I wonder, Carrie, if you have experienced that.
Oh, absolutely. And I've heard a lot of stories about, participants who, self-sabotage as they're, getting ready to graduate, because it's scary that support has been taken away. I think our practice is, our treatment providers work with them, and it's no surprise that the standards indicate that before they graduate, they should be focusing on having a plan. What are your triggers? What's your relapse prevention? How do you continue to take care of yourself? And we have great treatment providers, outpatient, inpatient, mental health as well, and they really focus on helping the participants. And we always, and I know a lot of other Healing to Wellness courts do this as well, is that even when people graduate, a lot of them move on, but some of them, and I've heard this very commonly, that and we always tell them, if we're here, you can come back and visit us anytime. We hope we don't see you back as a true participant, but we're always here. Our coordinator is frequently sharing with us, so-and-so dropped by and gave an update, and it's nice that they still have that connection, because I think that that's important. But they certainly should have a plan. And Lauren, I should probably just note that we're already at 4 o'clock, even though the first key components contain a lot more information than the others, but just wanted to point that out.
Oh, I know. The time is always our worst enemy. So I'll turn it over for you for intensive supervision under key component 5. And I would say 5 and 6 are definitely our next important key components. And 7, 8, and 9, we usually spend 7, 8, 9, and 10, we usually spend a little less time on. So we'll be okay.
Yes. But like I said, if people have questions, let us know if we start going too fast. So number 5 is a critical component to Healing to Wellness, and that's that intensive supervision. And it's done a lot of different ways. It's done through frequent and random drug testing, and it needs to be random. We always joke, when we say random, we truly mean random. Random does not mean you know that you will get tested on the day you have Healing to Wellness Court. It's just random whether or not your name will come up. There should be some other component. People do it different ways. Some people do it really fancy, where they have a computer program and people call in, and that randomly their name is chosen. Other people, if you're small enough, then your coordinator does it randomly. And there should also be some case management as well. Not everybody is able to have a case manager. Sometimes that's the coordinator, but that's a critically important component as well. I see we have a question, and Lauren, maybe you can help with this one. How is motivational interviewing for change tied in with evidence-based treatment? The only thing, and I don't know that that's in the slide, so I'll just kick it off and then hand it over to you, Lauren.
Sure.
That I think the research has shown, it used to be back in the day when we trained people, we used to tell them, oh yeah, you should do this, there were these different readiness to change interview techniques out there, and we used to encourage people to do that. And now the research is telling us that that's not panning out, that it's not any sort of indicator. So that's all I know about that, Lauren. I don't know if you have a better answer.
Okay, I think that's actually something different. You're talking about suitability interviews? If someone...
Well, she said, okay, thank you, but I don't know.
So, well, I think you're right, Carrie. I think that a lot of the research is showing if someone is ready for change or not, should they be in drug court. The research is showing in either case, whether someone shows they're ready for change or they're not ready for change, we seem to see similar outcomes for drug court. So both individuals should be in drug court. But motivational interviewing generally, training for all of our team has been really good, especially for the judge, having motivational interviewing techniques that they can employ from the bench has been proven to be really, really effective. So I would say avoid suitability interviews at the beginning for your participants, but encourage motivational interviewing for all of our team members.
Excellent.
And maybe we should skip the poll since we don't have a whole lot of time.
Okay. We do have another question. What tribes are you using MAT, and what kind of MAT? I think the most common one out there is Suboxone, and I know Penobscot had a program that does it. I don't know any of the other ones off the top of my head, Lauren.
Yeah, so I think there are actually quite a few tribes.
Yeah.
I unfortunately don't keep a comprehensive survey of what tribes are using it, but I know quite a few are. I know Swinomish had their own Suboxone clinic, and so they had a drug court specifically for participants that were on MAT. Penobscot was an interesting example because their doctor actually was on the team, and so I thought that was a really good model. I think I think Carrie's right. I think Suboxone is the most popular, but we're seeing a lot of Vivitrol being used.
Oh, right.
And so I'm not an expert, but Suboxone and methadone are generally sort of substitutes for the opioid, and so they replicate the same kind of effect, but it's in a controlled environment, whereas Vivitrol, and I apologize, I'm not using the correct medical terminology, but Vivitrol inhibits the brain's ability to enjoy the benefits of the opioid, so it's almost like an inhibitor, and so you can take all of the heroin that you want, but you won't enjoy any of the benefits. I unfortunately don't know off the top of my head what tribes are using Vivitrol, but we operate a tribal drug court listserv, and so great. And so I can pose this question onto the listserv and hopefully connect you with tribes that are using MAT so that you can connect with them.
Okay, so I just want to mention, I already mentioned random, and that if possible, the best random includes nights and weekends. So that goes back to who you have on your team and whether or not, law enforcement is willing to do drug tests or urine tests and probation officers, if you have those. Best practice, best standard is to be random and do it on nights and weekends because that's when people use. And also do it frequently and don't reduce it until the last phase. Which I think is not I don't want to say new, but it's something I think that not all of us have been doing because we didn't really have the research. We used to decrease it a lot sooner, but I think it's incredibly important to because that's what keeps people accountable. And so I'd encourage you not to reduce your urine testing, your drug testing until your last phase. And let's see. You should always be witnessed, whoever is doing your drug testing. Make sure chain of custody and all those sorts of things. Essentially, the standards are saying that whoever is doing your drug testing should be trained in how to do that. And also make sure that it's very clear in the participant contract about how they're going to be tested and what includes what signifies a positive or what happens when they refuse and that's considered a positive. And test for everything, right? Don't just test for one thing. Here, we change up what tests we're doing, whether we're doing a saliva test or a urine test. And so the participants never know until they're actually tested. And then, so the standards are also, since we're talking about supervision, is making sure that they're getting the treatment and social services that they actually need in addition to substance abuse counseling. And it's no surprise all the things that they need. So focus on, the responsivity needs, criminogenic, maintenance, and I want to get to the one slide here. It's really important, to focus on in the correct order, and the research has backed that up, that focus on the things that are very responsive, like housing, right? If you have, phase one, if you have a person who doesn't have a home, that can be very critical and can result in them, one, you can't find them, and two, can increase their ability to relapse. And then as you go on, you can, like in phase 4, deal with educational, vocational needs. Phases 2 and 3, you can deal with delinquent peers. It's important, again, if you have case managers, and that's something you can include in your grant proposals, and work on that. I see we might have some more.
Yeah, maybe, Carrie, I see we have 2 additional questions, and we're going to open up for Q&A in about 5 minutes, so we'll address your questions in just a minute.
Okay. So it's also important to make sure that they have family and interpersonal counseling. I've seen some great examples, and I try to do that as well. So we have an adult Healing to Wellness court, and we also have a family treatment court. But even with my adult criminal court, who they're all on criminal probation, we spend a lot of time during our court hearings, each one of them talking about their family and what's going on. And I learned that watching other Healing to Wellness court judges who ask people about their families and how they were building or rebuilding those burnt bridges, and it's fun when they start doing well and to see them happy, and that's the rewarding part of Healing to Wellness court, and so and knowing the programs you have in your family. We've had people that have gone to the training, Fatherhood and Motherhood is Sacred, and so, and know the services in your community, so you can, even if they're not on your team, you can send people to that. And again, I have participants who are struggling. They don't have a lot of skills. I think that happens with, job skills. That happens with a lot of our participants. And, a lot of places I've been, that's part of their phases, that they either need to be enrolled in some sort of program or education, or they need to get a job as they obviously get further along, perhaps phase 4. And so then your team works with them to help them find their place in life and helps them find those skills so they can be successful. And so I'll pass it off to you, Lauren.
Okay, and I apologize we're running out of time and screaming through this. But you have access to all the slides, and you have access to us whenever you would like us. With sanctions and incentives, we've made reference to these phases. Each wellness court designs their own phases, but as you've seen, there's some guidance, or at least some guidance from the best practices, that ideally you want to structure your program so that it's 9 to 12 months, and it tapers down, focusing on the immediate needs such as housing, and then tapering down and focusing on to more of the lifestyle needs like vocational and educational needs. Typically, there are 4 phases. I've seen some tribes with 3 and some tribes with 5, with the 5th one being more of an aftercare focus. But then within each of these phases, we have different requirements, and it really varies from tribe to tribe. But usually there's a community service component. You need to go to so much counseling depending on your treatment plan. You need to maybe write an essay to graduate to the next phase, and different things like that. Drug testing being another big requirement. And so because of all of these requirements, there are lots of opportunities for complying or not complying, and this is where sanctions and incentives comes in. Because you're going to be having Healing to Wellness court probably every week, though the standards, the best practices say at least every other week, provides really good outcomes, you're going to have an opportunity to quickly respond to each of these. Either you had a good week or you had a not so good week. Maybe you had all negative drug tests, but you didn't show up to one of your appointments, or you showed up late every time. So what we want to do with our incentives and sanctions is quickly respond to our participants' behaviors, as opposed to the adversarial system where we don't respond to anything until there's a huge blow-up, there's a new offense, and now we have to come down with the hammer. So we're responding immediately. The big takeaway here is that we want to be open about what the possible incentives and sanctions are. Ideally, in your participant handbook, you're going to have a list of what the possible incentives and sanctions are and what the possible reasons for getting an incentive and sanction are. You know, an incentive being you had 3 good weeks in a row, you get an incentive. A sanction, you had a positive drug test, you're going to get a sanction, things like that. We use the Goldilocks approach. There's definitely a happy in between. You don't want your sanctions to be too severe that your participants just get habituated with the negative consequences, and you don't want them to be too weak so that there's no real penalty. And we also have the 4-to-1 ratio. An incentive doesn't necessarily have to be monetary. It doesn't necessarily have to be a gift card. An incentive includes a congratulations from the judge, an applause from the audience, just an acknowledgement that I see that you are making an effort here. You showed up. Good job. There has been great studies on the beneficial outcomes coming from those kinds of acknowledgments coming from the bench. Get that. Carrie, if it's okay with you, I'm just going to zoom through this so that we can get to our questions and answers.
Absolutely. I was going to suggest that.
So I'm going to go past our poll, too. Just as a quick overview for the judge is the only team member that has their own key component as well as their own standard, and this is because the importance that the judge has on the outcomes simply can't be overstated. The judge is seen, for better or for worse, as an authoritarian position, and when the judge says that you did a good job, that goes a long way. The judge is also the leader of the team. They're setting the tone for the entire team. They're usually the one calling the meetings. They're the leader through and through. This goes in through, our hearings every 2 weeks, ideally. The 3 to 7 minutes, this is a magic number that's come up. If the judge can spend at least 3 minutes each hearing, so this is, our hearings every other week with each participant, we see better outcomes. We see participants more likely to graduate from Healing to Wellness Court. In Indian country, the really neat thing is that I would say pretty much at every single site I've ever been to, the judge is spending far longer than 3 minutes with each participant, which is great. The only balance I would include there is that, especially as we want to attempt to increase the number of participants that we can serve, watch the clock. Nobody wants to sit in a 3-hour hearing every week, so there's definitely a balance that needs to take place there.
Especially your team.
Yes.
They'll be very mad at you.
Another takeaway is that a Healing to Wellness Court is still a court, and the judge is ultimately the final signature on the order. We encourage a lot of teams to take a holistic team approach to the wellness court, and so a lot of teams will, in their staffing, this is the meeting taking place prior to the hearing in which all of our team members sort of gather together and talk about the participant's progress that week. They might vote on whether or not a participant needs to be sanctioned for whatever crazy behavior took place that week. That's just fine. However, if the judge ever disagrees with the vote, at the end of the day, it's the judge's order. And so we encourage the judge to feel like they can sometimes go against the team if they feel that they need to, because it's a court and it's the judge's order. This also goes into rules about just the general structure of a wellness court, due process, and judicial ethics. Different teams have different ways of doing this. This is ultimately going to depend on your own judicial code, but that is the general takeaway, at least from stateside. The rest of the key components concern the overall structure and maintenance of the Healing to Wellness Court. Key component 8 concerns monitoring and evaluation. We highly, highly, highly encourage you to have your own data management system for your wellness court. Your wellness court should be considered a different docket, and so maybe you have a different case number for cases that are referred into this docket. But ideally, you want to be keeping information on each of your participants each week. This is not just for the importance of court reporting, which is critical, but also so you can make sure that your participants are progressing the way that you want to, so that you know if you need to terminate a participant, you can track what their progress has been, and ultimately so that you can show both your community and your funders that this is in fact a successful program that's more cost-effective than not doing wellness court. Key Component 9 concerns training. All of you are currently in compliance with Key Component 9 because you're attending this webinar, so excellent work. There are lots of recommendations on the different types of training that we want our team to get, including, specifically, you'll see the standard concerning the judge. As I mentioned, there are a couple trainings coming up. You can find more on our website. And finally, the last key component is about team interaction. I would say about 99% of the wellness courts that we visit have some issues pertaining to key component 10. All of the benefits that are included with wellness court coming together as a team include all the struggles of coming together as a team. It's hard working as a team, especially when we're coming from different professions, and it's something that we have to continuously work at. We, TLPI, are here to help with that. There are lots and lots of different strategies. Some teams really strive at it, but no team is issue-free. And so if ever you feel like things are coming to a head, at least know you're not alone. Some strategies include making sure that your policies and procedures are updated and reflective of what your actual practices are. And then MOUs, Memorandums of Understanding. As much as possible, putting down in writing the commitments that you have made to each other goes a long way just to formalize that relationship. Okay, so those were the key components and the standards. Sorry we had to rush through that at the end. I just wanted to give a shout out to Carrie, who did a presentation on this topic with Charlene last year at our enhancement training. I pulled a lot of their resources for this presentation, so that's this slide. And then here are a couple of online resources where you can learn more. I especially want to draw your attention to the third one, drugcourtonline.org. I think they're working on a new website now, but this includes a whole bunch of webinars on particular issues, such as one on like just incentives and sanctions, that if any of your team members, your fellow team members weren't able to join this webinar, or you'd like to learn more about a particular topic, this is a great resource. Oh, and here's our website. This is where you can find a lot of our resources, including I'll be posting this presentation. So right here at Prior Event Resources, the yellow highlighted tab, that's where you can find all of our past presentations. And now we can turn over to questions. So our first question, do you recommend ankle monitors for 90 days as standard for everyone or on a case-by-case basis? Ankle monitors, usually Scram bracelets, which is a company that offers those, they generally detect alcohol consumption. And so for that reason alone, I would say that's a good case-by-case call. It's generally for individuals that are in wellness court for some kind of alcohol-related issue. Although, as Carrie mentioned, when we're doing drug testing, you want to be testing for multiple substances, especially because as a participant weans off one drug, they sometimes will turn to another substance, and so it's very possible that a participant will start using or abusing alcohol when they hadn't before. But generally, I'd say case-by-case basis, but I think it just depends.
I would agree. I think, to be honest, I think depending, again, what's going on with the participant, we've never done 90 days. I mean, I have to check with our coordinator before the participants, before I came on the bench, but I don't ever remember her saying that they did it for 90 days, although it's possible. But I've done it for a week or 2 weeks. And then the second question, so if there are other questions, go ahead and type them in now. But the other question we have up there, are there any potentials for increasing the number of medications used in MAT? And she gives an example, one that I'm not familiar with, but that doesn't mean anything. And so I don't know, Lauren. Do you know the answer to that question?
Yeah, well, I'm not familiar with the Bunavail. Sorry, I don't know how to say it. But it sounds great, right? I know a lot of the critiques of MAT stem from the fact, especially with Suboxone, that it can be abused by participants and can potentially be sold on the streets. The feds have come out with protocols for what a MAT program should have, and most of those protocols are against abuse. And so it's, intensive monitoring, making sure that a doctor is overseeing each prescription, all of those things. And so if you have an MAT program in your community that you don't think is in compliance with those protocols, it's really important to bring that to the attention of somebody. But to get at this specific question, yes, it's definitely possible for different medications to be in use, but it ultimately is going to be up to the prescribing doctor in charge of that clinic. I know some doctors have preferences for what medications that they're going to be using, so you'll see clinics that are, Suboxone specific or Vivitrol specific. So it's ultimately going to be up to that prescribing doctor.
And that's also a good question for the listserv. If people are interested in joining the listserv that Lauren does through TLPI, it could be, that some of our other treatment providers are familiar with that, maybe even some of our consultants.
Yeah, there's also a rural drug court listserv. It is what it says. It's both tribal and non-tribal, but they are a very active listserv that also do questions back and forth. So if anybody's interested, they have a great back and forth. Sometimes it's too many emails, though, I will say that. We tried to implement, but so there's a follow-up question from Meredith. We tried to implement Bumenaval, but Medicaid, primary payer, wouldn't cover it because of an agreement with Suboxone. Oh, that's terrible.
Yeah, and and dealing with the MAT, obviously you're going to have to probably be dealing with Medicaid as well, or some depending on how it gets paid for. So that can add in an additional wrinkle.
Yeah, sorry. No, that sounds just like a definite slow response from Medicaid. And so hopefully that can be addressed. But I know many programs, it's like ultimately we have to pay for this somehow. And so where Medicaid is going to cover it, that's going to be what binds us. I know some drug courts have applied for drug court funding specifically to pay for such treatments as MAT. But so many of these federal funds are short-term, 3 years, and so it's not a great sustainable response to something like treatment that our participants need access to.
Right, and that also brings up a good point. So, many of your participants have to deal with, your local IHS clinic, and or some other type of clinic, and it's kind of up to you whether you want someone from them on the team, but at least it's good to know who those people are, so you can reach out and say, okay, this didn't work for this participant, we couldn't get this covered, but can we start the conversation, because, we want to be able to do this in, perhaps down the road, and how do we open those doors? Do they just need more research to prove that it's acceptable, something like that?
Well, on the screen, you see our email, wellness@tlpi.org. If any questions come to you later on in the day, please feel free to reach out to us, and I'm sure that's open for Gina and Carrie as well, and I'm happy to filter any questions their way or that way. Also, as I mentioned at the beginning of the presentation, we have technical assistance that's available, so you can always feel free to reach out, big question or little question. And finally, I mentioned 2 trainings. There's the training at the NADCP, that's the big behemoth drug court conference. It's got all of the major players there. If you and your team can make it to that conference, that's definitely one of the best resources to get drug court training. That's going to be taking place July 9th through 12th in D.C. this year. And then we, the Tribal Law and Policy Institute, will be hosting the Healing to Wellness Court enhancement training. That's going to be September 12th through 14th in Albuquerque, New Mexico. Our website, enhancementtraining.org, has more information. I will be posting the agenda in a couple of weeks, and we'll also be opening registration soon. And that is free for everybody. You just have to get to Albuquerque. And then the following month, it looks like NAICJA will be having their conference also in Albuquerque, October 11th through 13th. NAICJA always puts on a really great conference with a really diverse agendas, and so I highly encourage you to attend if you can.
Thank you so much. This is Gina Jackson again, and I appreciate everyone who was able to join the call. Like Lauren and Carrie have both mentioned, training and technical assistance is available to tribes. If you don't have a specific drug court, but so many components in tribal justice fit together, we also want to make you aware that we also have training and technical assistance to tribes through NAICJA, specific to CTAS program Area 3 and 7, as well as TCLA. And so you can put requests on our website through this link that you see here, and we welcome any questions you have and are just so excited that we were able to have this webinar and some really great conversation. It was also mentioned that if folks are interested, we can look at developing more in-depth or more specific webinars in this area, and we would love to hear from you about that. So thank you so much, everyone. It's time. We appreciate our speakers today and everyone who